Good afternoon, everybody. My name is Andrew Zwerling. I'm here with my colleague, Nicholas Summo. We're attorneys at Garfunkel Wild PC, and it's our privilege and our pleasure to conduct today's webinar entitled Managing the Remote Workforce, Employer Best Practices and Legal Considerations. I see that participants are loading as we speak, so I'm just going to hold off for a couple of seconds before moving forward to give everybody a chance to sign on. We had a pretty large registration list, and we want to give everybody an opportunity to hear what we have to say from the beginning. I will add that it was really nice to see a whole lot of familiar names on the registration list. So for all of you, hello, it's nice to see you back again. While we're waiting for the others to load, I'll just give the requisite background about Garfunkel Wild, about Nick, and about myself. Our firm, for those of you who do not know us, we've been around for over 45 years. We're a full-service healthcare law firm with about 90 attorneys in New York, New Jersey, Connecticut, Florida, and Washington, D.C. And by full service, it's healthcare, litigation, managed care, biotech, health law, mental health, and relevant to what Nick and I are going to talk about today, employment law. With regard to Nick and myself, if you haven't worked with us before, and again, judging from the list, there's quite a bunch of you who have worked with the two of us. Collectively, we have decades of experience as litigation attorneys, as employment lawyers, handling matters from the trial court level to the U.S. Supreme Court. And as we've said many times before in conducting these seminars, we play two different roles. We do day-to-day employment counseling, but we also know our way around the courtroom and how to litigate. And we use the information that we learn and pick up in the litigation to see how a client may have handled something correctly or less than correctly, and we use that to inform our day-to-day counseling and to insert an element of pragmatism when we give advice and putting out fires of various types on a regular basis. Also, for those of you who know us, we don't like giving speeches. We're going to present a lot of material for everybody, but we do encourage questions during the presentation itself. You're going to see on your laptop or your desktop, there's a chat box feature. So type out your questions. Nick and I will do our best to answer them in real time. Worst case, if we can, you'll know how to reach out to us. We'll do our best to answer your questions, after the webinar itself. So as far as today's topic is concerned, it has become increasingly common for employers to have employees work remotely, particularly in light of all the technological advances that have made it a lot easier to do so, to perform many job duties outside the confines of a traditional office. While a lot of people use COVID as a starting point for the acceleration of remote work, it existed beforehand as well, whether in hybrid form or in fully remote form, because there are a lot of advantages to permitting your employees to work from home. Some obvious ones: reduced overhead and operational costs. You need a smaller footprint with regard to office space. You can use work from home as a recruiting tool to attract new employees. On the recruiting front, rather than work from a smaller geographic pool, you can have the entire country to tap into for hiring opportunities, with also an ability to, have a different pay rate for people who may live in other parts of the country where the cost of living is less. Reduced commuting costs and stress, increased retention, productivity, and morale, and improved work-life balance. So there have always been a lot of advantages. COVID really, it acted as an accelerant, but remote work has been around for some time. That said, there are certain issues that could come with allowing employees to work remotely, again, whether in a fully remote or hybrid form, that you really need to watch out for. And Nick and I are going to walk through what some of those issues are and to help increase your level of awareness about those issues and give you some practical advice on how to navigate those issues. So what are some of them? Wage and hour compliance under the Fair Labor Standards Act, including ensuring that employee hours are accurately tracked and compensated. Questions on whether telecommuting qualifies as a reasonable accommodation under the Americans with Disability Act. Remote work, you're going to have less control over where your remote employee stores confidential information and trade secrets, and remote work will implicate other information security issues that you really need to watch over. Workplace health and safety issues, including recording and providing workers' comp for on-the-job injuries and occupational illnesses. There are going to be some minutiae that one wouldn't readily think of, but we're going to walk through you with, again, just to increase your awareness of what some of these traps for the unwary may be. And just general challenges associated with remotely managing employee performance and other aspects of the employment relationship, including productivity levels. So we're going to address these issues in methodical fashion. Again, we encourage you to ask questions as we move along, and we'll do our best to answer them. So moving on in terms of the next slide, telecommuting policies. I cannot stress enough, because we've had counseling inquiries from clients involving issues that could have been avoided had there been a telecommuting policy in place. So I can't stress enough that having a written telecommuting policy in place is a critical first step in addressing some of the challenges you're going to face as an employer employing a remote workforce. If you have a well-drafted telecommuting policy, it's going to serve many different objectives, including, but not limited to, defining one's eligibility to telecommute. Not all of your employees necessarily, depending upon the nature of your workplace, are going to be eligible just based upon their job descriptions to work from home. And having a policy that sets out the criteria or the eligibility criteria will be helpful in informing your employees who may or may not be eligible. Why is that important? Just one, in a pragmatic way, it'll keep people from reaching out saying, why not me? When the quick answer is it's because the particular role that they perform doesn't, in a logical way, permit for remote work. Your policy will also provide a specific procedure for requesting approval to telecommute. If you have a small workplace, maybe you don't need, some strict protocols. But in most workplaces where you have dozens or hundreds, or thousands of employees, you're going to need some formal protocol in order to have organization and to have order with regard to these requests and to monitor and supervise these requests. The policy will explain the conditions of an authorized telecommuting arrangement. For example, it'll detail the employee's responsibilities and expectations, such as, what are your work hours? How are your hours going to be recorded if you're working from home? What is your accessibility during work hours? So when working from home, maybe they have distractions, small children, elderly parents, where they're going to move back and forth away from their workplace area. You want to spell out for them the need to be accessible during work hours. You also want to have in a policy what the protocols are with respect to supervisors reaching out after work hours. Someone's working from home, you figure they have their desktop or their laptop. I'll just shoot them an email at 9 o'clock at night because I, the supervisor, want to get this off my plate. You want to have a policy and practices in place, that spell out what is or isn't permitted with regard to the accessibility issues, because just as a quick one-off, if you start emailing people after hours, it can implicate wage and hour issues. The policy should spell out the frequency of communications with the employee's manager. What's expected of the employee with regard to keeping their supervisor in the loop, okay? The policy should spell out how to safeguard company equipment and confidential information, what the workplace setup is going to be, including ergonomics, what furniture and equipment the employee may be responsible for providing, what are the conditions for using, maintaining, and returning any employer-provided equipment, including what's the employee's responsibility for any intentional damage. One's child knocks over the computer, it breaks, who's responsible? You want to spell these things out ahead of time, and it's not about shifting any employer obligations to provide equipment that may exist under law, or responsibility for wear and tear or otherwise other destruction of equipment. It's not about shifting it to the employee, but placing rightful obligations where they should be in a written document. You want to spell out in the policy in a related way, who's responsible for paying for what, work expenses and things like that. You're also going to want to put in that policy, what are your responsibilities as the employer? What technical support will be provided to employees? A lot of places you have a help desk or an IT central help desk where an employee can just call up and call the help desk. You want to make sure that that communication line and that support is in place, but also that the employees working from home are aware of that. So if they encounter an issue, they're not losing time trying to sort things out. Again, the flip side of the same coin, what expenses, what workplace equipment the employer is going to be responsible for providing, for maintaining, for repairing, whether it's cell phones, computers, teleconferencing equipment, fax equipment, antivirus software, the list goes on, but you want that spelled out, ahead of time to avoid problems that may come down the pike as things just happen in the normal course. You want to designate in that policy the employee's specific job duties, work area, break times, to avoid liability for injuries that are not work related. If someone's working at home and they get injured, on the job, well, were they on a break? Were they not on a break? Is it during work hours? You want to spell out this kind of detail, just so everybody is on the same page and everybody has the same expectation levels. And again, it's worth stressing, reminding employees that they're expected to comply with you as the employer's policies, including electronic communication policies. All right. So again, I just bulleted through some of the variables that you're going to want to have contained in that policy, but there's a critical need to have that delineation and to articulate it and communicate it to your employees. Okay, electronic signatures, nothing new about that, simply because we're talking about remote employment, because when you have onboarding, when you have applicants, even before having nothing to do with remote employment, electronic signatures have been around for some time. For remote applicants and employees in particular, the submission and exchange of many important documents is going to take place exclusively using electronic communications. And many employers have, just as a natural consequence and from a point of view of pragmatism, have developed an electronic system for managing these documents and rely on electronic signatures from applicants and employees instead of the traditional handwritten signatures. But there are risks associated with the use of electronic signatures. But if you engage in certain best practices, you can dissipate that risk. So for remote applicants, you're going to have employment applications. You can have consent for background checks. I'm just giving you some examples where electronic signatures are going to be implicated. New hire paperwork, tax documentation, immigration documentation, employee benefit enrollment forms, as well as employee handbooks and other policies where you're going to want them to acknowledge receipt. Employment agreements, where those occur, they may not be for the rank and file necessarily, but you're going to have people electronically sign employment agreements that might contain arbitration clauses, confidentiality provisions, restrictive covenants, non-competes, non-solicitation, etc. Again, electronic signatures may be utilized. Acknowledgement of evaluations and discipline documentation, again, may be electronic. Okay, and again, timekeeping records that's a day-to-day one. So many of these documents are going to require the applicant's or employee signature, because let's face it, especially in a large workplace, it's not practical to think you're going to get hard copy signatures. Many employers, as a consequence of that and recognizing that reality and just recognizing the pragmatism behind electronic signatures, have established an electronic system for managing these documents and relying on electronic signatures from these, whether it's applicants or employees, instead of the traditional signature. With regard to some codified law that pertains to this, they're essentially guided by two federal laws. One is the Electronic Signatures in Global and National Commerce Act. The other is the Uniform Electronic Transactions Act. And both of these define what an electronic signature is. And they're intended, this codified law, really to promote and validate electronic signatures, in terms of their use. And again, they've been around. Just the codified law gives you a foundation, a legal foundation that permits it. All right. But the authenticity and validity of an e-signature can still be challenged by an employee or challenged by an applicant in the case of consent for background checks, for example. They may claim the signature is not authentic, and we've dealt with that situation where the person claims forgery. Nick and I are working on a case now it's not an employee mint situation, but where the individual who signed the release is claiming that it was a forgery. So people can still claim that it's a forgery or it's a mistake, or that they gave consent to a different version, electronic version of the document, not the one that you're seeking to enforce. So what are some best practices that we advise that you engage in? One is include electronic consent language when seeking an electronic signature where applicable. Another best practice that we advise is ensure that any documents that need signatures are actually signed by the remote employee by some electronic method, as this is sometimes overlooked when collecting documents electronically. Another example that we advocate using, although you don't have to use any particular technology to create a valid electronic signature, consider using vendors, software, or technology to ensure electronic signatures are unique and verifiable, and to help avoid claims that a signature is a forgery or a mistake. These methods may include digital signatures, biometric signatures, signature capture devices, and identity verification services. You want to really ratchet it in to protect yourself against those claims, as rare as they may be. When they occur, they can be problematic. Because electronic signatures or documents can be easier to alter than hard copies, ensure that any document requiring a remote employee signature was not altered before it was electronically signed, which is something that you would do with a hard copy anyway, right? Before you send it out, you want to make sure that there's been an exchange between parties about the content of the hard copy. You want to make sure that the version everyone's signing is the one that you actually agreed to. Don't, let your guard down simply because it's an electronic document. Make sure you're sending the correct document to be signed. You should consider memorializing your practices in an electronic signature policy. Have a written document distributed to all employees, including remote employees. And lastly, and again, what Nick and I are talking about today, it's not specific to any one jurisdiction. You want to be familiar with any state laws governing electronic signatures where the remote employee resides or the employer operates that may apply. Again, if you're based in New York, your workplace, but you're dealing with a remote employee in Idaho, okay, you want to know what the laws are in those respective jurisdictions and what the interplay is between those laws. So if a problem arises, you know how to navigate that.
So Andrew's explanation and discussion about electronic signatures is a nice segue to our next topic, our next slide, which is the hiring process. It makes sense that often if there are remote employees, their application process, and even later if they're taken on as employees, their onboarding process would be done online. It's not always practical. As Andy had mentioned, you might have an employee, you might be a New York-based company or a New Jersey-based company, and you're recruiting, which is one of the benefits of remote work. You might be recruiting someone from Hawaii or Idaho to come on board. And it doesn't make sense from a practical standpoint to have them come in to fill out applications. So those critical application documents and later onboarding documents would be done online. So two issues that are very important with respect to the application and the hiring process are electronic signatures, as Andrew had discussed in detail, and ADA accessibility. Electronic signatures, and I won't repeat a lot of what Andrew said, but explain why they're so important for the hiring process. When an employee signs a document, whether it's an application or a policy or an acknowledgement that they've received a policy, that signature generally indicates that they are attesting to having received and reviewed the document. That's important. From a standpoint as an applicant, you want that employee to say through their signature and on an application form, I am attesting to everything that's in this application is complete and accurate. That's important because you might have on an application information that an employee is giving about their background, about their qualifications, about skills or licenses that they have. You want to know when they're joining your company that they are accurately conveying their background information. The other important thing is when employees are getting onboarded or they're joining your company, they are provided a bunch of different documents and information. Policies, as Andrew had mentioned, regarding maintaining confidential information, whether that's trade secrets, so information that the employer wants to keep secret, but from in a medical standpoint, there could be HIPAA protected material that is protected under federal law. The employee has to know that they are going to be governed by various policies, and their signatures on those documents will indicate that they understand that. Having a signature on it on an application process also allows, in the event that the employer finds that information was falsified, to take disciplinary action. It's a lot easier for an employer to say, well, look, we're going to have to let an employee go or institute some disciplinary action if they notice or they find that information has not been accurately conveyed if there's an employee signature on it. Employers will often provide their employees with documents that make clear that they're at will, which means that none of the documentation that they would be signing creates an employment agreement. That means that the employment relationship can be terminated on either side by the employee or the employer for any reason, of course, any non-discriminatory reason, and at any time. Having an employee sign that they understand that they're not going to have an employment contract is very important, and it also some states require those information to be put up front in an employment agreement, an employment application, or in an employee handbook. It also employers will also provide new employees or potential employees with information that says the employer cannot modify existing policies or benefits or even alter the at-will employee status to a contractual status absent a signed document from an authorized person in the company. So it's important that employees, when they're signing those documents, they're made aware of that. And again, as Andrew mentioned, and as litigators, we deal with this. The best indication that someone has seen and acknowledged information is through a signature. It's a lot harder for someone to say, well, I don't know that, when their signature is at the bottom of a document. Of course, it's not perfect, but it is, from a litigation standpoint, from a counseling standpoint, very good practices. In order to, with electronic signatures, our firm uses a great system. There are ways that enables only the person who's logged into a portal or into the network to sign their name. For instance, I can't, on our system, can't sign a document with Andrew's signature. There is a unique password to protect that, just like Andrew couldn't sign my name. So there are very good ways that employers, I should say, can make sure their system works to protect the application process through electronic signatures. Another important issue with respect to the hiring process, and it's one that Andrew and I counsel and deal with from a litigation standpoint, is ADA accessibility. ADA is the when we hear the term ADA, it means the Americans with Disability Act. The federal statute requires that employers make their online presence, whether it's their website, whether it's their application portal, whether it's their employee network, accessible to people who may have hearing impairments, visual impairments, or even physical impairments. There might be people who can't use a mouse and need other ways to navigate, an online system. Unfortunately, all too often, we've seen our clients get into issues where the site it's alleged that the website is not in ADA compliance. There are website content accessibility guidelines that are a great resource for prospective for employers who are dealing with remote applicants to just double check to make sure that their website, their application portals have all of the things that would make any applicant, whether they are visually or hearing impaired or maybe disabled, physically disabled, to navigate easily to submit a process and then to be onboarded. We've dealt with Andrew and I investigations not in the employment context, but issues where the federal government has decided that a website wasn't compliant, and the employee would then have to go and hire a vendor to do that. And that was an investigation. It wasn't even a litigation, but it took a lot of time and effort to resolve. And the issue that one may not consider, but it's a real reality, is if one employer has a website that's not necessarily compliant and one or two applicants are having difficulty, that runs the risk that other applicants might have had similar issues. And the litigations I've handled in this context have always been prospective class actions, which can be very difficult and expensive to resolve. So it's best that just in terms of best practices and risk aversion, risk assessment, get your websites up to date and ADA compliant. Those websites will often have a little widget on the side that indicates that, and it allows the user to navigate the website based on their specific needs. So it's a great way to ensure that you are avoiding one potential risk with dealing with a remote or online applicant or employee. With respect to new hire information and policies, employers have to make sure that they are providing their remote employees, after the onboarding process has been completed, with the same documents and information that their in-person employees are getting on the ground, on site. It's important when, as I had mentioned earlier, there's a ton of information that employees get, whether it's through on the onboarding process, when they're applying, that detail all sorts of policies that an employer may have. I had mentioned that these can be handling and storing confidential information, whether it's the employer's or it's HIPAA protected material of some sort, if that information is handled by the employer. It's policies about remote work, as Andrew had mentioned, policies, EEO policies, sexual harassment prevention policies, complaint provision. So an employee who has felt that they've been discriminated against can lodge a complaint, and the process for doing that. Having employees, those documents transferred and disseminated to remote employees is as critical as it is for employees who are on the ground in a brick and mortar office. It may be difficult to think, but it's not. But we see this all the time. Just because an employee is not in the office and dealing face to face maybe with their colleagues, that doesn't mean that discrimination issues can come about. It's critical that those employees are made aware of all the policies that are governing their relationship with the employer. Now, another issue, not just with respect to policies, but many employers have employee handbooks. It's important that when those are sent out, there are ways that the employer can track who received them. A lot of times, the documents will allow for electronic signatures, but there are other methods. The employer can employ software that allows a box to pop up where the employee will click and select that they've read it and received it, and it will record that receipt for the employer, so they can keep track of who's receiving these policies. It's critical, and Andrew had mentioned telecommuting policies. It's very important that when an employer is dealing with remote employees, whether it's email communication, it's the emails that attach documents, that those policies, what the content of those policies are very clearly laid out. You don't want an issue where someone is saying, well, I received something different than an employee who's on the ground, or there's a discrepancy in that. Having these written policies creates a system of uniformity, and it allows a clear expectation. So when we're asked about an issue, we can say, well, was there a policy in place? Was it followed? That consistency can avoid issues and really does help mitigate against any risks in terms of litigation or complaints about discrimination. With respect to wage and hour.
Yeah, before we move on, just from a technical standpoint with regard to sending policies out and communications out to your employees, have a system in place that requires an affirmative response from your remote employees. That can include a signed acknowledgement, or it could have them, clicking a box on a computer screen that gets recorded, and have your software or system in place that has a tracking log that will monitor whether or not the employees opened the email and actually clicked on the links. You want to have that system in place. Again, someone can claim, I never received the email. They'll have an electronic trail. They can say, well, I never read it, right? Maybe you have a read receipt. But you want to have that technical software in place to, maximize the possibility of having proof that they acknowledge it by way of a signing or a clicking and so on. That having that documentation could prove helpful in case somebody says, I never received the policy, I never opened the email. Your software will indicate that at a minimum they had the opportunity to do so, or even more, that they did check a box, or that they did, you do have I'm using just a read receipt as an example, that you have something like that. So get that software in place with regard to whatever system you're using now.
I wanted to add one more thing with respect to receiving documents and making sure information flows the same way to the remote employee as it would to a in-person on-site employee. Critical tax documents like a W-4 for withholdings, or an I-9 in which an employee says and attests to being eligible to work in the U.S. You have to receive those documents for a personnel file the same way you would for an on-site or in-person employee. But the same thing, just the way many states would require in-person employees to have copies or documents showing the employer's corporate name, its DBA, its telephone number and address. Remote employees have to be given that information as well as information about the regular scheduled pay days, their rate of pay, and whether or not they're eligible to work overtime. So those critical pieces of information can't be missed for remote employees, the way you would have to ensure that they're provided to their on-site counterparts. Remote work also creates wage and hour issues that need to be addressed and could be could create certain issues. The federal Fair Labor Standards Act requires that employers pay employees for all the hours that they worked, even hours that are not requested, but the language is requested but suffered or permitted. And so if an employer knows or reasonably should know that their employees are performing work, they have to get compensated for that. Now, there are ways to guard against, or at least create a system that's in place to ensure that an employer is properly managing their employees' time. For instance, the FSLA requires record keeping of all employees who are exempt. non-exempt employees. So if they are eligible for overtime, you're required to keep records about their time, especially their overtime, so as to ensure that they're properly paid. But then if there are any discrepancies, those records will reflect the time that they work. So it's best practices for an employer to develop a comprehensive policy that dictates how employees clock in, when they start their day. What do they do? Some companies use hand scanners that will, once an employee walks in, they're listed at every entrance or exit way. You scan in by your hand, the employee's clocked in. Some companies require or have a system in place where you can type it into your computer when you log in that you start your day. Those have to be done as part of the federal record keeping requirements. Your policy should also make clear the method for requesting overtime. Obviously, if an employee works overtime that they didn't get permission for, you still have to pay them. But that does allow the employer is certainly permitted to discipline that employee, including up to termination. I and Angie, we regularly draft overtime policies for our clients that make clear that excessive overtime that was not been pre-approved by a supervisor that can result in a variety of disciplinary actions. Certain policies with respect to record keeping should also require that the employee attests that their time that they're submitting for the week or for 2 weeks is accurate. That obviously allows you to track and say, well, this person's saying this is when they work. And then, if it's been falsified, well, then you have policy that says we can terminate or discipline our employees who are falsifying their time. Another good practice is to allow or to have supervisors review the time that has been submitted by their direct reports to ensure accuracy. Now, some people may say, well, what does that do? Well, supervisors will have a sense of what their subordinates are working on. If you know that Jones has been working on a big project or had a very tight deadline, and you see that he logged in a certain amount of hours, you say, well, that makes sense based on what this person was doing. I know that they've been very busy, but if you see that there's been an excessive amount of time when that person may not have been as busy, well, then there might be an issue with that. There are ways that employers can monitor. There are softwares that allow that check that monitor keystrokes, and it monitors activity on the computer. So if an employee says, "Well, I worked 8 hours," well, your IT system can check, and you can say, "Well, you weren't logged in for 8 hours, and so how is that possible?" It does allow for a system in place to monitor.
Just a couple of more points on the wage and hour issues. And I'll use just a simple example to illustrate the point. If my legal assistant is working during her lunch break and I see that going on, then she has to get paid for that, even if I didn't tell her to work during her lunch break. That goes to the, suffer language that Nick mentioned just earlier, right? But at least if she's working in the office, I know if she's working through lunch. If someone is at home, though, that line between work and home is just obliterated. And so, how are you going as an employer going to know if somebody says, I know my work hours, I'm using an example, 9 to 5, whether they go, I had to pick up my kid from school between 3 and 5. I'm going to work from 9, I'll make up the hours, or I'll work even longer hours. Or I'm going to have a crazy day tomorrow. I'm going to work tonight after I have some peace and quiet in my home. You want to avoid that situation as an employer, because if you know about it, you have to pay the employees for it. That's what the law requires, and that's only fair. But the issue is, what if you don't know, right? So you want to have a comprehensive system and a written policy in place that says you have to record your hours. Here's the protocol if you're going to work outside of your normal hours. Overtime, as Nick points out, you need authorization. And you want to have all of those pieces in place, because we've had litigations where there were even systems in place where the employee filing the lawsuit said, well, the supervisor who I can say I did overtime with or to give the form to was walking around the hospital. I didn't see him. I couldn't give him the form, right? The more systems you have in place, the more incremental safety nets you have in place, the greater your ability to refute those kinds of claims. And it's not just about protecting yourself from a lawsuit. You want to have a nice, smooth interaction with your employees, right? You want to have good morale. You want to have just, you know, tension-free relationships and so on. So you want the expectation levels to be bright and visible. So telling them how to record their hours, telling them the need for approval for overtime, a protocol in place if they happen to work, you know, after hours or whatnot. You want to have that really nailed down for their benefit, your benefit, for the collective benefit.
So tax and employment law considerations. So it should come as no surprise that when you have an employee working in another jurisdiction, there creates a physical connection to an employer to that state where that employee is located. And this can create or give rise to a variety of tax and even workers' compensation issues. When you have an employer who is hiring a remote worker or utilizing a remote worker, whether their business operations are within that employee state, where the employee lives, whether whether the employer is having the employee work at home for the employee's convenience or the employer's convenience, creates a variety of tax issues which may require the employee to pay tax both within the state that they live in as well as the state that they're telecommuting in. It also gives rise to potentially state taxation issues for the corporation. They might be subject to tax within that state where they are employing a remote workforce. It also creates potential issues with workers' compensation. If you have a worker who's working from home in a different state than where your company is based and where it operates, you have to make sure that that state doesn't require the employer to have workers' compensation insurance where the employee is living or where they reside. One can imagine a horrific situation in which an employee is injured while performing work for their employer, and that employer does not have workers' compensation insurance for within the state. That can create a lot of liability and can be needlessly expensive. Some states, like New York, analyzes the taxation issue with the convenience test. If an employee is working from home for the employer's convenience, which means that the remote work is done at the request of the employer, that might prevent that double taxation. But on the other hand, if the employee is working because it's an accommodation or because they've requested it at a convenience, there can be taxation issues where they are subject to the taxation of their own state, which they file their state income taxes, as well as they have to pay withholdings to the state in which that they're telecommuting to.
And again, we're not going to go into any granular detail about the workers' comp issue, the tax issue, the unemployment issue. We're really here with regard to that limited subject area just to advise you to do your due diligence ahead of time, because we've encountered situations. Let me take a step back. Oftentimes, the remote work is going to involve employees who are located within your state. But we have encountered situations where employees were allowed to work in other jurisdictions and then they had to be terminated for whatever reason. Okay, well, what's the unemployment insurance landscape like if you're a New York-based employer and you're terminating a remote employee in Ohio or New Jersey, right? Is New York's unemployment going to cover it? Is it New Jersey's? What's the interplay? Okay, these are things you want to sort out to the extent you're going to go outside your immediate jurisdiction. Again, it's food for thought. Obviously when it comes to the tax points, you're going to consult your accountants, your CPAs, your tax attorneys, et cetera. But we just want to make you aware of those considerations so you don't get blindsided, with regard to these issues as they may arise. Next up, accommodation requests, telecommuting. And again, a lot of familiar names on that registration list. People who I've had the pleasure of working with and dealing with accommodation requests, the interactive dialogue, and so on. Telecommuting is a form of reasonable accommodation. So even though we're talking about a remote employment for anybody, you do have that specific subset of that dealing with individuals who are disabled, who may need to work from home as a reasonable accommodation for their disability. I'm going to walk through this a little more quickly. I'd rather touch and spend a little bit more time on some of the practical points in terms of the employer-employee relationship with regard to telecommuting, and I'm looking at the time, so I'll spend a little less time on this particular subject. All right, so telecommuting is a form of a reasonable accommodation. There are some people, maybe they can't physically commute. Either they can't drive, they can't take a train, they can't take even a taxi and so on to come to work, or the workplace itself, whether it's infrastructure or otherwise, is something that they are not capable of taking on due to whatever the disability may be. Where that occurs, where you get a request for a reasonable accommodation to work from home, that triggers what we call the interactive dialogue. Which means that it's literally a conversation with that employee about what middle ground can be reached between that employee, being able to work from home and what burdens or undue hardship may result to the extent that the employee does work from home. It's a true dialogue. I have never encountered a single instance where the employer simply said, no, I just don't want to do it. I'm fortunate to work with many clients, professionals who actually spend a considerable amount of time trying to problem solve in a way that's fair to the employer and fair to the employee. Doesn't always work out, but it's really a question of saying, or taking into account the variable, or what are the limitations of that individual, the employee's ability to perform the essential functions of their job, and how does working from home address those limitations, and whether or not the working from home is going to create some form of burden on existing staff. Again, there are going to be certain job descriptions, and I had mentioned that up front with regard to eligibility to telecommute or to work remotely. If you're a truck driver, you can't work from home. There are certain jobs that are going to require, regular, frequent, in-person dynamics, whether it's between colleagues, whether it's between the employee and a consumer, an employee and somebody who is requiring the services of the employer. You're going to take all of those variables into account. Maybe it would require the purchase of equipment that is prohibitively expensive, or maybe not. So you're going to want to walk through all of the costs, burdens associated with the remote employment to see if it's workable, including the ability to supervise that employee depending upon their job description if they're working from home. Okay, and again, there are certain jobs where the essential duties can't be performed from home, but we're really, those are easy. Those are the easy ones. You can't do that from your house. It's the gray area ones where, well, maybe you can, but it's going to impose certain burdens on the employer in one or more ways that, again, are excessive and that the law doesn't require the employer to take on. We'll go to the managing employee performance and conduct. And Nick and I have walked through a whole bunch of, subject matter. At the end, and that's true of all of these webinars that we're conducting in this particular series, we're trying to make it pragmatic, but really more to the point. All of this information is designed to enhance your ability to create a workplace that is employee friendly. Again, you're running a business, right? There are operational concerns. We all get that. But we're taking those into account and trying to show how operational and business concerns coexist or can coexist with an ability to keep morale, productivity, where you want it to be, where you want, to address employee engagement, et cetera. All right. So in many respects, this is the the heart of what Nick and I are putting together for you. All right. So one, the obvious. You're going to want to convey to your employees, we have this telecommuting policy. You're obligated to comply with it. All right. And if if you fail to comply with it, it can result in discipline, termination, et cetera, et cetera. Right. You want to put that out there just to let them know that there are rules for a reason. Okay. It's not, we're going to rule by the stick and rule by fear so much as these rules are in place and designed to enhance their ability to do a correct and good job, which is good for them. It's good for you. All right. But you want to impress upon them that, okay, you're working from home, the anti-harassment policy still kicks in. Payroll practice policy still kick in. Standards of conduct still kick in. We've had, when COVID hit and all of a sudden people had to work from home, it really was mind-boggling the number of cases Nick and I had to handle where people were just engaging in bad behavior on these Zoom meetings, whether it's what they were or weren't wearing, what they said, where they just felt like they were, treating it like, they were hanging out in some pub, talking to a bunch of pals, as opposed to, no, it's just the workplace in front of, on the computer. So you want to remind people that the same rules apply. If you wouldn't do it in the workplace, you can't do it simply because you're working remotely. All right. And it's not a tough message to impart. Fortunately, most people understand that. There's, in our experience anyway, less instances of that, online behavior than existed. I mean, COVID is crazy, but it's, 5, 6 years ago at this point. Those instances have dissipated, but they still occur. So you just want to do a gentle reminder, same rules, landscape is the same. You also want to remind them about employee data privacy, concerns, because that can be problematic in ways that can take off on anybody. Monitoring remote employee activities, their conduct, performance, it can be challenging because they're not physically at the same work site as their manager. That's obvious by definition. That's what remote work is. And so you're going to have concerns that your remote employees may be abusing their telecommuting arrangement. You're going to have maybe not actually working from home to the extent they should be. And employers, it's only natural, struggle with the most effective way to monitor and manage their remote employees in terms of performance, in terms of productivity. Some employers just do the pragmatic approach. We're going to rely on regular emails and phone calls and video teleconferences and maybe quarterly in-person meetings, put together a coterie of, calendared, scheduled contact to keep people in certain guardrails. And that's recommended. It's a healthy component of your ability to manage remote employees. Others, will rely either in whole or in part with electronic communication systems. There may be task monitoring software or other methods to review employee emails, including emails sent to and from the employer's email systems, or emails sent to and from the employee's personal email accounts, such as Gmail or Hotmail. If you see a lot of that activity going on where they're communicating to themselves offline, that could raise a red flag. You have software that allows you to monitor. Again, they're going to be using, workplace, employer provided equipment, so there's no expectation or reasonable expectation of privacy. So you can monitor internet usage, including what websites they may have visited using the employer's computer systems. You can monitor internet usage in terms of the content posted by the employees on the internet, for example, on blogs and social networking sites, whether at work or from home, or the amount of time they spend on the internet. Now, maybe their job requires them to do that, right? But maybe it doesn't. And if they're spending 3.4 hours, monitoring the internet, and you see a lot of Amazon purchases and whatnot, you got a problem, right? And again, it's going to be tailored to the specific employee and what their job duties may or may not be. There's software that can block employee access to inappropriate or illicit websites, from the employer's computer systems, or that has an ability to track employees' keystrokes while using the employer-owned computer. GPS, you see that with people, whose job descriptions require them to drive or deliver items with a truck and so on. There'll be a GPS monitoring system. If you know that the truck had to go from point A to point B, and all of a sudden the truck does a major loop, you're going to ask why. And maybe there's a legitimate reason why, but you'll at least have an ability to be informed of the need to ask the right questions. Okay. Now, while electronic monitoring of email and internet and login activity may be particularly appropriate for remote employees, there are certain risks of invading the remote employee's privacy that can be greater because the employee is now working in their home and sometimes using the employee's own equipment. So some best practices for workplace monitoring of remote employees and minimizing the risk of liability include, but again, these are just some examples, implementing and distributing a clear electronic communication systems policy, what things they are allowed to do, what things they shouldn't do, notifying remote employees that they have no expectation of privacy when using the employer's email or computer systems, and letting them know that their electronic communications using those systems, the employer systems, may be monitored. Put in writing an explanation for the employees, the business purpose of the monitoring policy, such as tracking employee efficiency and productivity, protecting against the disclosure of trade secrets, ensuring compliance with federal, state, and local laws and company policies. Okay, help them understand the reason why. Otherwise, it falls into that stereotypical big brother just wants to watch. No, the employee is watching for a business reason. It's not just to invade somebody's privacy. All right. You as an employer should also take steps to protect your trade secrets and other confidential information with remote employees. This is particularly true with regard to healthcare and PHI and privacy laws such as HIPAA, where there can be pretty harsh consequences if you fail to comply with those laws. Okay, so this includes providing information security training to your remote employees and instructing them to secure any employer property, to maintain confidentiality by using passwords and locked file cabinets if possible, maintaining regular antivirus updates and computer backup. And again, some of this will be handled by the employer, but it depends on the nature of the particular, landscape between that employer and the employee. Letting them know about keeping passwords safe and not sharing them with anybody else, and notifying you as the employer immediately if there's some unauthorized access or disclosure. If there's a problem, let you know the problem occurred so you can implement the fix before the damage becomes even more widespread. Avoid keeping confidential information in a place where family members could access. We had one situation where the physician had a fax machine in his dining room where PHI was being faxed to his dining room fax machine where his family members had access. Again, we dealt with the situation, but it's an example of what could be a problem, okay? Advising them how to dispose of sensitive documents, properly. So you really want to be vigilant in articulating, the need to have safeguards in place, to protect confidential information, to protect trade secrets, to protect against the wrongful disclosure of PHI and HIPAA breaches, okay? In addition to ensuring that your employees understand and abide by your policies and are working remotely in a responsible, proper, effective manner, you want to also, again, you want them to be engaged and productive. So you should, set out goals and expectations at the beginning of that remote relationship. Have that dialogue with them, where you're talking honestly, and we're not talking, it doesn't take hours to communicate these sentiments, okay? That you'll understand some of the issues that could arise. You'll give them helpful information on how to navigate those issues. really towards an objective of making sure that the communication line between the employee and the supervisor is robust and intact. You want to discuss with them how their performance is going to be measured and at what frequency. We've had a number of instances where the remote employees feel, I'm out of the loop. How is my supervisor going to supervise me and assess me and evaluate me when they don't see me as often? Like, how are we going to fix what they perceive to be this imbalance? And there are ways to deal with that, because there are certain, with a lot of job positions, certain metrics that provide objective-based feedback to supervisors, whether or not they see the person, whether or not the person's on site, right? You want to have a conversation and alleviate their concerns and even implement measures about how to maintain personal contact, all right? Okay, you can't see the person every day in person. Maybe we have quarterly meetings. Maybe we have Zoom meetings with greater frequency. There are ways to create that bond, that really critical bond between employee and supervisor, even though they're working off-site. You want to provide training to your remote employees, both on the job and more formally using webinars, online learning portals, video teleconferencing, or even in-person conferences, obviously not on a day-to-day because they're remote employees. Include remote employees in employer-sponsored events, if feasible. On communications, just because they're remote doesn't mean they're out of the loop. Include them in team meetings, again, using video teleconferencing, et cetera. You want them to feel like they're part of the team. And there are different ways, either through interpersonal dynamics, through the use of IT and so on, to help close that gap between them and their on-site peers, okay? Treat them the same otherwise, but again, importantly, impart to them that they will be treated the same, and that you as a manager, you as the employer are going to do your utmost, in a reasonable way, to again close that gap. So you see that I would, 1:32. Sorry for the 2 minutes of overtime. Again, it was our, privilege and pleasure to provide today's webinar. You have our contact information that has been provided to you. So, feel free to reach out to Nick, to reach out to me if you have any follow-up questions. Until the next webinar, have a great day, everybody. Be well.
Thank you.